Welcome, everybody. We're just going to get started in a minute. We're just having folks roll in. So you're welcome to introduce yourselves in the chat if you want. Name, any affiliation you want to give. We'll get started in just a minute.
Good morning.
Morning.
Good morning.
No, it is not.
Morning.
Good morning.
Good morning.
Morning, everyone. We'll be starting in a second.
Good morning, everybody. Welcome. We're going to be having a training today by Homebase about working with clients with criminal histories. And I wanted to flag actually the Housing and Workforce Integration Network meeting last week, HWIN, which is for sort of bringing together folks working in workforce and housing or homeless services. This was actually the same population that we focused on relating to employment. So we'll be sharing out the video from that meeting and training as well, because there's, as you know, lots of challenges for folks that have connection with the criminal justice system. I want to introduce Michelle Burns and Byla Byla Lindner from Homebase. And I'm going to turn it over to you all and just cue me when you want me to give you your polls.
Great. Thanks so much, Jamie. Good morning, everyone. My name is Michelle Burns. I'm a directing analyst with Homebase, and I'm joined today by my colleague, Byla Lindner. As Jamie said, she's a directing attorney, and you'll be hearing more from her a bit later in the presentation. I also had the pleasure of participating in that HWIN meeting last week, sitting in on that, and it was very informative and well done. So I'm glad that this, the timing of these trainings overlaps like this. So before we get started, I just do need to do my necessary note, because we are going to be talking about some laws and regulations today, and that just specifying that the content that we're going to be covering today is really for informational purposes and it's not legal advice. So just keep that in mind, please. If you could go to the next slide, please. We're going to do, many people already are just very familiar with Zoom, but just a couple reminders. Please, if you'd like to have your camera on, please do so. We'd love it, but also do whatever makes you feel most comfortable. If you have questions or comments during the presentations, definitely please add them into the chat box. And we will be getting to questions a little bit later in the presentation. Everyone is currently muted, but again, later there may be opportunities for us to have to come off mute to ask questions. And then, as was already put in the chat, we are recording today's session and everyone will receive a recording and a copy of the slides as well. Okay, next slide, please. Just to let you know who's here doing this training for you all today. Like I said, we're from Homebase, and we are a nonprofit. Our mission is to build community capacity to end homelessness and reduce poverty and to foster thriving, inclusive communities. And we are here as part of the Criminal Legal System Initiative, which is a component within Homebase. And we really seek to improve outcomes for those affected by the criminal legal system, with a focus on housing solutions, improving public safety, and reducing strain on public resources. And we'll be sure to share our email and website at the end of the presentation. So before going on, thought we would just pause and see who is in the room with us today. Jamie's going to send out, thank you, already a poll here that if you to just answer who are you from an affiliation perspective. Do you work in homeless services, reentry, legal services, workforce development, or none of the above? And we'll just take a moment to give you all the chance to answer that.
And is the poll showing for folks? Okay.
I can't see it.
Let me try it again.
And if you work with more of them, because like we do workforce development and so I just put homeless services.
Got it.
Okay.
It's funny, it's not showing people's answers. I don't know what's going on.
Okay, yeah, it's showing up for me, and it looks
Okay,
like
great.
I've had most people have answered now. So
Okay, I'm going to end the poll and then we're
Great.
going to share the results.
Great. Terrific. Okay, so it looks like we have over half of you all work in homeless services. About a quarter of you do something completely different than what we've listed. And then we have a mix of reentry, legal services, and workforce development. So that's great. Thank you so much for participating in that and letting us know who's here. Okay, if you could go to the next slide, please, just talking about what we're going to be doing today. So we will be discussing the intersectional nature of housing, homelessness, race, and the criminal legal system. We will be talking about what criminal histories can and can't tell you. We will be learning new ways to recognize and minimize housing barriers for clients with past convictions. And we will also be exploring specific considerations for people on the 290 registry. We might be identifying questions that we can't answer here. We may have the opportunities to share relevant life or work experiences, and we may also disagree productively. What we won't be doing is pretending that this work is easy. We won't be giving you specific additional housing resources. As I said earlier, we will not be providing legal advice. Of course, this conversation is not going to end with this training. This is one component of our work in this area. And also, we will not be coming up with conclusions or solutions, but we really do see this as an opportunity to share knowledge with each other and to try to move things forward in terms of better meeting the housing needs of people with criminal histories. Next slide, please. So what we'll be doing, as I said, we'll be starting off by discussing why we should talk about criminal histories and the limitations of talking about that. We're going to be going through some specific equity data, and then I'll be turning it over to Byla, who will be talking about fair housing law, and we'll also do a special population spotlight on meeting the housing needs of people on the 290 sex offense registry. So let's talk about why we should talk about criminal histories in general. Again, we have a lot of people here that are serving, that are in homeless services, also people in reentry, workforce development, legal services. We really see it as three major reasons for housing providers and housing systems to talk about criminal histories. Number one, they matter when we consider broader equity issues. Two, they create barriers to finding and sustaining stable housing. And three, understanding these barriers can help us serve our clients better. So let's drill down into these a little bit more and look at the first reason, which is really what matters when we consider equity. The next few slides, what I'm going to be doing is really giving you some data points, and we're going to go from national to state to local level. And you'll definitely see there's a lot of commonalities in the data in terms of who is being incarcerated, who is experiencing homelessness. So if we could go to the next slide for the national data, what we're talking about is That at the national level, formerly incarcerated people are actually nearly 10 times more likely to experience homelessness than the general population. And Black, Indigenous, and other people of color and LGBTQ+ individuals are also disproportionately represented in both the homelessness and criminal legal system. Next slide, please. Black adults make up 12% of the US population, but 33% of the prison population and 43% of adults experiencing homelessness in our country. Just going to pause there just to let that sink in, because I think we talk a lot about disproportionality. It's something that we are aware of as providers and policymakers and people working in this field, but really looking at the numbers and thinking about what each of those numbers mean. LGBT individuals are 3 times as likely to be incarcerated. And one study showed that LGBT individuals experienced homelessness or housing instability at a rate over 2 times that of non-LGBT individuals. So that's at the national level. Let's go to the next slide and look at California. We really see, again, the same trends at the state level. In California, Black people make up 6% of the state population, but 27% of people experiencing homelessness. Black Californians are imprisoned at a rate 9 times that of white people. And Black and Latinx people have higher rates of unmet mental health needs than the rest of the population. And thank you, Jamie, very much for your reminder in the chat that these, yes, we're talking about these as results of systemic issues, definitely not discussing this as in any way like a result of individual decisions, but really looking at it as a systemic issue. And I'll also note that the slides where we have these data points, when we send these out, the slides have footnotes to the sources with links to the specific studies so that you can all also look at them later on if you'd like to. Okay, let's now look at Contra Costa specific data. So we know in this county, Black people comprise 9% of the general population, 39% of the population experiencing homelessness, 38%, and 40% of the county jail population. So again, we're really seeing a very disproportionate impact in terms of homelessness and criminal legal system involvement for Black people and other people of color in our community. So the second reason we really want to talk about criminal histories is that they create barriers to finding and sustaining stable housing. And so we want to figure out how can we become more aware of what the situation is in order to reduce those barriers. So convictions carry not just immediate consequences for the person who's incarcerated, but also long-term consequences for both them as well as the broader community. If you could go to the next slide, please. So here we're talking about collateral consequences. So these really refer to the consequences that follow a person after they have been released from jail or prison and are really baked into our laws and regulations. So these are long-term consequences that are baked in, and then we also have additional consequences that are not part of laws or regulations, but have significant impacts. And these consequences can be directly housing related, or they can be one step removed. These can include the type of business you own, or the license you obtain, or the job you can get, or your right to vote. And all of those things, even if not directly linked to housing, certainly ultimately do directly link to our ability to obtain and maintain stable housing. And then some of the collateral consequences also relate to specific laws and regulations. And Baila will be discussing more of these specifics later on in the training. So now what I'm going to do is, and thank you very much for the equity training link, Jamie, that you put in the chat. That's great. So now what I'd like to do is, if you could go to the next slide, we're just going to pause and ask you all to, sorry, the slide right before that, thank you, to consider what kinds of barriers are experienced by your clients who have been impacted by the criminal legal system, and ask you to take a moment and put your thoughts into the chat. What kind of barriers do you see in your work with your clients? Or if you're a person with lived experience, what kind of barriers have you experienced because of your impact by the criminal legal system? And I will just pause for a moment, give you all the chance to write in there. Seeing stigma, finding and sustaining stable housing, employment and housing. Seeing housing a lot, specifically for people with who are on the 290 registry, the mindset of not being prepared to change, lack of communication. Yep. Transportation and financial barriers. Yeah. Reunification with children and family. Benefits, therapy. Yep. Mental health support. Yeah, stigma I'm seeing again, lack of education surrounding housing and expectations around housing. Yes, and that is something definitely, Bila's going to be talking about that more in terms of what are the laws around housing and housing restrictions. Yeah, so thank you. This is really, and feel free to continue to put things in the chat. I think just what I'm seeing is a lot of commonality in terms of what people are identifying as the primary barriers in really meeting the needs of clients who have been impacted. Yes, child support. Yes, definitely things. There's so many ways that people are impacted, and that whether you are the person directly impacted or not, there's so many ripple effects, of course, because we are all part of the community. So thank you all for sharing that. And definitely, yes, please continue to put things in there. Wanted to talk for a moment about the scope of the collateral consequences. So every year in our country, over 600,000 people enter prison and 10.6 million people enter jail. 67% of the people held by jails have not been convicted of any crime. So someone can be arrested, detained, and released, but they have still had that experience of being incarcerated. And while being detained, there can be certainly additional consequences that can begin to pile up. You think about every relationship that person has, whatever their housing situation is. So for example, you can have a person who is living in their vehicle. They are arrested and detained in jail and then released. But while they were in jail, their car gets impounded. And so when they're released, regardless of whether they were convicted, they are returning to a place where they don't have a residence anymore. That has disappeared. And that's an example of the type of collateral consequences that we're seeing. Technical violations are the main reason for incarceration for people who are on probation or parole. So these are extra rules that people on probation and parole have to follow. But they're non-criminal violations. So they could be something like not checking in with a parole or probation officer, or not completing a counseling program that's being mandated by the court. And so again, these are not crimes, but what we're seeing is that people on probation and parole are getting reincarcerated at high rates because of these non-criminal violations. Okay, next slide, please. The final reason I'll talk about in terms of why we talk about criminal histories is understanding them can also help serve our clients better. So what we're going to do now is do a quick poll, get your feedback about how your organization or agency uses criminal history information. Do you use it for eligibility screening, for housing placements, referrals to community resources, case management plans, or all of the above, and there's also an other. So I'll just pause for a moment, let you all take a moment to finish the poll.
Michelle, it's showing, right?
Yes, it's working.
Okay, great. It's not
Yeah.
showing for me, so just tell me when you want to close it
Yeah.
and share it. I don't know why it's not showing.
Yes, right. It's a Monday. Great. Yeah, and people responses are coming in. Great. So what we're definitely seeing is a lot of all of the above. Eligibility, housing, referrals to community resources, and case management plans. Great. I'll just give another couple seconds. Okay, great. Yeah, Jamie, you could end the poll now. Thank you. Great. So as you can see here, we have definitely the majority is all of the above. So using criminal history information for eligibility screening, housing placements, referrals to community resources, and case management plans. Great. Thank you. So what I'd like to talk about now, if you could go to the next slide, please, is what can't we learn by looking at client criminal history? So we've talked about, part of it is important to look at it, but it does not tell us everything. So we're actually going to start with what can't we learn, and then we're going to go to what can we learn. So first of all, we can't necessarily see what the final outcome was. So depending on where you get the criminal history information, there can be limitations on what you can use when making housing decisions. So rap sheets include lots of information like arrests, and but it's very important to look at the final disposition or outcome of the case, what actually ended up happening, and also to keep in mind that these reports can have errors. So looking at them, you just want to keep that in mind, that they're not always completely accurate. The other thing we cannot tell by looking at someone's record is whether our clients are dangerous to themselves, to other clients, or staff. And this really can be a challenging one. If you see a rap sheet and what that can represent, but it's important to remember that it doesn't provide the full context, such as situations of abuse or trauma, substance use disorders that are now being managed, and other medical or mental health issues that are now being managed. And obviously, it's very important and necessary to keep ourselves and our staff and other clients safe. And it's also important to push back on our assumptions and to remember that there are systemic and personal contexts that aren't visible. So going back to what you all put in the chat earlier about, what are some of the biggest barriers? Again, stigma and assumptions that we can make about each other based on criminal history information. Another thing to remember that we cannot tell is whether our clients are trustworthy. So looking at criminal history information, we might find out that someone has been convicted for shoplifting. Does that mean that they are untrustworthy, or does it mean that they were committing a crime of survival? We don't know, right? So just keeping that broader context in mind. And then the final one is about deservedness. So just remembering that we do live in an environment of housing scarcity, service scarcity, and as a result, there has to be prioritization. And it's important that we remember that because there are not enough resources, we tend to have then a moral deservedness ladder. And we can't tell if someone is deserving of housing based on criminal history information, but that's a trap that we can tend to fall into. So just keep remembering that that is not something that we can to push back against that, is that's not something that we actually can tell or should try to tell from someone's criminal history information. There are some, you can go to the next slide, please. There are some tangible benefits to looking at criminal history information. And so for those of you who don't use it, we definitely encourage you to consider using it in ways that are beneficial to your clients. The first thing it can provide is an ability to better target services. For example, there are services for record expungement. There are mechanisms to ask to be re-tiered on the 290 registry. And Byla, as I said, we'll be talking about those more in a moment. A huge piece of it is, of course, the ability to understand the whole client. And part of our role is to be sure that clients do not feel alone and that they have a sense of belonging and community with service providers and other people with lived experience. And so having a sense of what their lived experience is important. And if that includes criminal legal system history, then that's important to know. It also gives us the ability to use trauma-informed approaches, especially as related to custodial trauma. So, for example, there may be housing options that really might not be safe for a client based on their history of incarceration and carceral trauma. And lastly, the ability to ensure that housing options and supports are aligned with any community supervision requirements. So, for example, if you can't live in a certain neighborhood or with a certain family member, or you're not allowed to associate with certain people as a result, as the conditions of your parole or probation, it's very important for people in positions of support to have that knowledge to better identify workable housing options for participants. So with that, I'm now going to turn it over to Byla to talk a little bit more about specifics.
Hey, thank you, Michelle. I just want to note before we get started a couple of things that this is going to be very dense, the rest of this training. I just want to apologize in advance. There's just a lot of information that we want to share with you, so bear with me, through the density of the next hour or so. And then the other thing is that my son is homesick, so you might hear like Toy Story in the background or other things happening. And that's not part of the presentation, but you might hear a little bit of noise. So forgive me for that. Okay, so now we're going to talk about some of the laws about how housing providers in California can and cannot use criminal histories to make decisions about who to house. In California, there are several civil rights laws, including those listed here. And today we are going to focus on the Fair Employment and Housing Law, or FEHA, as it relates to addressing housing discrimination against people based on their criminal history information. FEHA applies to all of the different types of housing listed here, and I'm not going to go through all of them, but you will see that it applies to private housing, such as single-family homes, multifamily housing, and apartments, as well as transitional housing, supportive housing, residential hotels and motels and shelters. So in other words, FEHA applies to your programs and the landlords and property managers that you work with regularly. And what is your role with regard to FEHA? So since these laws apply to your programs and to the other forms of housing your clients are trying to access, this means that you need to know about FEHA to fulfill two roles. So as a housing provider, you need to make sure that you are not unlawfully excluding people from your programs based on their criminal histories. And as a housing case manager or housing navigator or other advocate, you need to know so that you can help prevent discrimination or address discrimination against your clients as they're looking at other forms of housing. FEHA mirrors the Federal Fair Housing Act, which some of you may already be familiar with. And it also mirrors guidance provided by HUD about looking at criminal history information, but it's more detailed and more comprehensive. And that is the reason why today we're focusing on FEHA, because you're in California and you have the benefit of FEHA, as opposed to looking at the Federal Fair Housing Act. So what does FEHA do? FEHA protects people from housing discrimination based on certain protected characteristics, such as race, color, national origin, religion, and disability. Having a criminal history is not a protected characteristic, But regulations that went into effect in January 2020 made it essentially unlawful to base decisions about access to housing on criminal history information without having a legitimate justification for doing so. And this is because using criminal history information in making housing decisions can have a disproportionate impact on people of color, as Michelle has already discussed. And people of color are a protected class under FEHA. So what do I mean by criminal history information? So FEHA concerns arrests, convictions, information that someone was questioned by law enforcement, other outcomes of criminal court cases, basically anything that has to do with involvement with the criminal legal system. FEHA works by setting limits on how housing providers can consider criminal history information. So the first key FEHA limitation to be aware of is that housing providers can only consider criminal convictions where someone was convicted in a court of law or found guilty. Housing providers cannot consider other criminal history information such as arrests, information about being in custody, infractions for things like speeding, and criminal cases that did not lead to convictions, such as those where someone's case was dismissed ultimately, or a case that's been sealed or expunged, and also outcomes of juvenile court proceedings cannot be considered. And the reason for this is that, I think there's a general understanding that when anyone can be arrested at any time for any reason, and you can be charged with crimes, but that doesn't mean that you are guilty. It doesn't mean that you have actually done the thing that you have been arrested for, that you've been accused of. So until you've been convicted, you're presumed innocent. And then even after conviction, society has determined that you've paid your debt, you're out, you're doing your thing, and you're supposed to have a chance to begin your life afresh, and perhaps even go through the expungement or sealing process. And it's important that, that housing providers honor that as well. The next limitation is that if housing providers do consider convictions, they can only consider convictions that are directly related to housing. And in identifying whether a conviction is directly related to housing providers should consider the nature of the crime. So did it have anything at all to do with someone's tenancy or housing at all? Did it involve, for example, setting fire to the property or massive property damage? So thinking about the nature of the crime in itself, the severity of the crime, right? How serious or dangerous was it? Was anyone hurt? That kind of thing. And how long has it been since the crime occurred? So those are some of the factors that people need to consider when they're considering whether something was directly related to housing. And the reason for that is that people can be convicted for crimes, most of which have nothing to do with housing, right? Or that have nothing to do with how they'll be as tenants and nothing to do with housing, especially if the conviction is particularly old. So for example, if someone has been arrested or has a conviction for possession of cocaine and it was 10 years ago, they're very differently situated than someone who was, recently convicted for violently assaulting their landlord. All right. The next limitation is that FEHA also prohibits the use of blanket bans for people with certain types of convictions. So for example, having a policy that says we don't accept anybody with a felony or no one with an assault conviction can live here, those will not pass muster. And the reason for doing that is that it shows that the landlord is not making that individual determination about whether or not the conviction is directly related to housing. All right, what other considerations are there when thinking about FEHA compliance? So in general, a housing provider's criminal background check policies and procedures should be in writing. And those policies should include what they look at during screening and why it directly relates to housing. Policies should state that they will give an applicant a copy of whatever criminal history document was reviewed. So for example, if a property manager or if your program looks at rap sheets or third-party background check documents or documents from law enforcement agencies, they need to provide that to the person whose record it is for two reasons. The first one is that a lot of times these records are not accurate. And so people need to have an opportunity to check for accuracy and to be able to correct them. And then the other reason is that people need to know, like, what is this decision based on, so that they can try to provide what we call mitigating information, which I'll talk about in a minute. And then the housing provider's policy should also state that they consider any mitigating information that someone provides when they apply. Okay, so what is mitigating information? Mitigating information is information that explains that the applicant is not likely to pose a demonstrable risk to the health or safety of others or to the property. And so, for example, mitigating information might be talking about how you were very young when you conducted the criminal acts, that the crime occurred a long time ago, if the conviction was related to a disability. So, for example, if you're on the 290 registry, because you were exposing yourself in public while having a mental health crisis, that could be mitigating information. If you were a survivor of violence, of domestic violence, human trafficking, then, at the time of the criminal conduct, then that might be a mitigating factor. If you've completed any services related to the criminal conviction, that would be mitigating information. So, for example, if someone was convicted of robbery 15 years ago, but they were using drugs at the time and they've since completed a drug rehab program, that should be considered. So if you are a housing provider, you should ask for and consider mitigating information when an applicant asks for admission to your program. And if you're a housing navigator or case manager or helping clients find other housing, you should help clients find and present mitigating information to landlords and property managers. So that's really, really key. And if your client believes that a landlord or other housing provider has violated FEHA, you can help them report violations to the Department of Fair Employment and Housing, which I actually think is now called the Department of Civil Rights, the California Department of Civil Rights. My bad, I should fix that. They are the agency that is tasked with taking complaints and investigating them. So that is one way that you can report FEHA violations. Okay, so before I move on, I want to take a moment to pause and see if people have any questions. Feel free to put them in the chat or come off mute. I know that was a lot of information, so just want to give people a second to let it sink in, etc. Okay. Great. And if you have questions in a few minutes, if you have questions in a few weeks, you can still reach out and ask them. So this is not your only opportunity to ask questions. Okay. So now we're going to move on to working with clients on the sex offense registry. And in particular, California's sex offense registry, because that's where you're located. But before we get into that discussion, I want to acknowledge that talking about sexual offenses and safety concerns can bring up a lot of different things for people, and it can be very triggering or upsetting or confusing. So I thought I thought I would give everyone a moment to just check in with themselves and also think about the following questions. What does this discussion bring up for me personally? Does it bring anything up for me emotionally, anything physically? What assumptions do I have about people on the registry? And where do those ideas come from? How might these ideas impact my work with people on the registry or my willingness to admit them to my programs? And how can I challenge those assumptions? And what education or resources would I need to make this happen? So just for a moment, turning the lens on ourselves just to see, how am I approaching this topic? So I think that's a very important part of all this, is being honest about where are you coming from. So now carrying forward that curiosity and thoughtfulness, I want to answer the question, why are we talking about housing and the 290 registry, aka the sex offense registry? You'll hear me use those interchangeably. First, as you know, we're never going to end homelessness and related systemic inequities if we don't confront our biases and assumptions about people involved with the criminal legal system, including those on the registry. Second, people on the registry have some of the highest barriers to accessing housing of anyone in our society. And this is evidenced by the fact that about 20% of people on the 290 registry don't have housing. Why is that? Because people on the registry face many long-term consequences of their convictions that impact every aspect of their life. Taking up from where Michelle left off with those collateral consequences. Many of these consequences are the result of laws or regulations that prevent people on the registry from having certain living wage jobs or living in certain places. For example, Jessica's Law, which prevents some people on the registry from living within 2,000 feet of a school or a park, limits, where people can reside. And just a really, I think, staggering statistic about that is that after Jessica's Law was passed in 2006, the number of Californians experiencing homelessness who were also on the registry skyrocketed from 88 to 3,229 people over the course of 2 years. People on the registry also have a difficult time obtaining housing because their high visibility and public stigma related to being on the registry encourages landlords and housing providers to exclude them without taking a closer look at the risk they actually pose. And we know that is true because we hear housing program providers talk about it all the time, about screening people out through criminal background checks. And for those who do serve people on the registry, they talk about how hard it is to help their clients find stable, affordable housing. Now turning to what do we actually know about the registry? California requires people convicted of any one of over 100 crimes to register their whereabouts periodically with law enforcement. The list of crimes is very broad. It ranges widely from misdemeanors to felonies. Some examples of convictions that frequently require registration include public nakedness, selling a sculpture or paintings depicting child nudity, possessing images of child sexual abuse, sexting, rape, and urination in public. And the reason I bring up these very different convictions is to drive home the point that there is a wide range of crimes that land people on the registry. So not everyone on the registry is a violent predator. And also, I want to point out that this wide range of crimes means that there are teenagers who have sexted each other and people who have raped other people on the same registry facing the same consequences. So this is just one reason that it is important to look beyond registration status to what the conviction was and any related mitigating information. We also know that the California Department of Justice's Megan's Law website, which is the registry essentially, publicly posts many registrants' names, address, conviction history, and appearance. This is very different from the way that our society treats any other conviction. For example, there's no public registry for people who have been convicted of homicide. People on the registry reflect a full spectrum of economic statuses, racial and ethnic demographics, sexual orientations, gender identities, and ages, which means, among other things, that there are youth who are on the 290 registry who were convicted of various crimes while they were still children themselves. We also know, as we have discussed, that being on the registry significantly restricts certain freedoms otherwise available to non-registrants, and that these restrictions severely limit housing options. So another really important thing to be aware of about the California Sex Offense Registry is that as of January 1st, 2021, the registry is tiered, meaning there are different levels to being on the registry. Before this, everyone, regardless of the conviction and whatever you did, you were required to be a lifetime registrant. That's no longer the case. And lifetime registry made everyone ineligible for certain HUD-funded programs, such as Section 8 and public housing. However, now that there are 3 tiers, people are, everyone except for people in Tier 3 is not a lifetime registrant, and they may be eligible now for Section 8 and public housing. Another thing that changed is that people can now petition to be removed from the sex offense registry entirely if their conviction, if they've basically fallen into a tier and have now spent more time on the registry than what their tier says. This does not occur automatically. People have to actively petition to be removed from the registry. So, as a provider, if you have a client on the registry, you should definitely find out if they're eligible to be removed, and we can share a resource to help with that later on. Okay. All right. So returning, I don't know if you can hear my son downstairs. Hopefully it's not bothering you all so much. Okay. So returning to FEHA for just a moment. I bet at least some of you were thinking when I was talking about FEHA, like that's really great, good for FEHA and all, but sex offenses are different, right? They're completely different. Like we're not talking about sex offenses. I want to make it clear that FEHA applies to all criminal history information, regardless of the nature of the alleged crime, and that includes sex offenses. FEHA includes sex offenses. This means that any housing exclusion based on someone's registry status must meet FEHA requirements, including no blanket bans, unless, for example, you have a HUD-funded, if you're running a HUD-funded Section 8 housing program and you are prohibited by HUD regulation from allowing people who are lifetime registrants, right? That is that's one exception to that. So no blanket bans. And as a reminder, this is because housing providers have to take an individualized approach to reviewing applications to make sure exclusions are directly related to housing. And if you have a blanket ban, you're not doing that. Okay. Turning now to serving people on the sex offense registry in HUD-funded housing. There are so many misconceptions about this, so we want to look at what the law actually says. So for CoC funded programs, you want to look to the CoC program interim rule. And that says that if the housing program is site-based, right, project-based, and it has in residence living there at least one family with a child under the age of 18. So if it's site-based and there's a minor living on the premises, the housing program may exclude registered sex offenders from the project. They may, they do not have to. And that's only, again, if it's site-based and there's already a child living on the premises in the building. For Section 8 in public housing, HUD only requires that public housing authorities deny access to people required to register for life on a sex offense registry. Anything more than that is discretionary. So your public housing authority may have in their administrative plan that they, want to exclude people who are, anyone on the registry, right? I'm not going to get into the legality of that. But what HUD says is that they don't have to do that. They're only required to refuse entry to people who are required to register for life. So those are two of the most common HUD-funded programs. So just want to make that extremely clear. Also remember that FEHA applies to HUD-funded housing in California. This means that anything beyond what HUD requires people to exclude may violate FEHA. That's, anything that a program uses its discretion to go above and beyond what HUD says they can't have, the kind of convictions that they can't house. That's, they have to take accountability for whether they're violating fair housing. So to illustrate these points, I'm going to provide two examples. The first one is let's say that a CoC funded site-based permanent supportive housing program in California is screening someone for their program, and they find out that the applicant is on the sex offense registry. So again, CoC funded site-based permanent supportive housing program. And that program has a child who is residing on the premises. Under the CoC program interim rule, they may exclude this person, okay? But HUD is not requiring them to screen that person out. And actually, guidance from HUD states that they would consider such an action as contrary to housing first principles. However, if the PSH program wants to continue with the screening process and they want to screen this person out, their process has to comply with FEHA. So the program has to conduct an individualized assessment of the person's conviction and any mitigating information to make sure that the exclusion is directly related to housing. Another example related to Section 8 could be someone is in Tier 2 of the California Sex Offense Registry. That means they have to register for 20 years, and they apply for Section 8. HUD would not require the Public Housing Authority to exclude this person. Because they are in Tier 2, they are not required to register for life. However, if the Public Housing Authority in their administrative plan has used their discretion to go beyond that, then that has to comply with FEHA. Their process has to comply with FEHA. So they have to conduct an individualized assessment of this person's conviction and consider any mitigating information to make sure that exclusion is directly related to housing. So this, a lot of people just assume that, you know, HUD funded can't serve people on the sex offense registry. That is absolutely not true. There's so much misinformation out there. So I just really wanted to take a moment to drive this home, that this is not coming from HUD, except in the case of public housing in Section 8 with the lifetime ban. So does anyone have questions so far? Yes, Jamie, the tiering is such a big deal. It's going to change, it can change a lot of different lives. Absolutely, yeah. Just noting a couple of comments here. So in the past, I've worked with some sex offenders, and while not condoning judging their behavior, you as a case manager want to support your client, yes. And let's all remember that these folks are out. They're out. Someone's deemed that they can be out in the community. They're out, they're living their lives. And, you know, it's not for us to determine whether or not they, you know, are a public safety issue. That's, you know, that's on law enforcement. They've been released. And says, no, our CoC has PSH programs that can serve or service individuals on the sex offender registry, including lifetime registrants. Excellent. Okay. All right. So if I'm not hearing any questions or comments or anything else, I will move forward. Okay. So just a few considerations and tips. What can you do to address barriers and increase housing for people impacted by the criminal legal system? One thing that's really important for you to do is, with your client's permission and with your clients, you want to go through their criminal history. And again, this is if they want to, if they're in agreement, you don't want to, you know, push your client to do anything that they don't want to do. But if they're okay with it, you want to go through their record with them to check for accuracy and also to identify any convictions that might cause issues so you can sort of get in front of them when they're applying for housing. Once you have looked at their record and you've determined that everything is accurate, you want to develop a targeted plan to address those barriers. So, you know, what might come up with this or that conviction? What could help explain that? What letters from service providers? Could we get a letter from, you know, probation? Could we get a letter from a counselor, whoever could explain sort of what you're doing now, maybe a former landlord, maybe a former, you know, rental record. that existed after you were released. Lots of different ways to be creative about what mitigating information could be. And then you also just want to learn about what are the reentry specific programs in your community. It sounds like there are a lot of workforce development opportunities, or potentially employment assistance for people involved with the criminal legal system. You'd be very surprised once you start digging to find out what specific resources might be available. And you may want to refer your client to legal services for record clearance or other related legal help. And here we provide information about the Contra Costa Public Defender's Clean Slate program. I think there might be some people from the public defender here today. If you are here, feel free to chime in. But anyway, we wanted to put their information up there just so that everyone is aware that that is a service that may be available. Okay, just a couple more. Obviously, you want to understand FEHA restrictions and other civil rights laws, but this is very important as it relates to housing. So you want to understand FEHA and how someone's criminal history can and cannot be used. So again, no blanket bans. Housing providers can only consider convictions, and those convictions have to be directly related to housing. You want to rethink document readiness. So I think a lot of times people, when they're thinking about housing applications, they're thinking ID, maybe a rental history, I don't know, social security card, different things that landlords, may want to see, income, all that kind of stuff, letter from, the subsidy provider. But you want to think beyond that with someone who has a criminal history, to really think about, okay, what else can we put in that rental packet that could help get in front of or explain a conviction that might pop up? What types of mitigating information can we, provide? And you have to kind of make a judgment call about whether you want to provide that up front, right? Because you know that the landlord is going to conduct a criminal background check, or if you want to wait to see what happens, to see if there's a denial. That's sort of a decision that you need to make based on your own experience. Okay. And then another thing that's really helpful for you to do is figure out, how can you help your client tell their story? How can you help them reframe their history for landlords and property managers? Because they're their own best advocates. They know their lives best. They know, what they've been through. And if they can explain sort of where they've been, what happened, not providing any information that they don't feel comfortable sharing, not hiding information, not providing false information, but really, taking a strengths-based approach, highlighting all of the things that they, that are true about them, that makes them a good tenant, kind of helping them figure out how can they present themselves in their best light to a landlord can be very, very helpful. Okay, just a couple of tips for reducing housing barriers for clients on the 290 registry. So we actually, at Homebase, we have a whole sort of resource about this, which I can share in the chat, or perhaps Michelle can put a link to in the chat. But this is a very, very abbreviated version of that resource. There's a lot more to this, but because we didn't want to overwhelm you, this is basically what we have for today. So one thing that you can do is help with post-denial advocacy. So again, private landlords, thinking about that mitigating information, what kind of advocacy can you do? If the public housing authority denies access, what can you do? I'm not sure, like if Bay Area Legal Aid, there might be people from Bay Area Legal Aid here, or other agencies help with challenging public housing authority denials. But anything that you can do to kind of help advocate when a client is denied access to housing. This is one that is a little bit tricky, but using the Megan's Law website as a resource to see where people are housed, right? Maybe identifying landlords who, are willing to rent to people on the registry, et cetera. The thing about that, though, is that people on the registry cannot look at the registry. They are prohibited by law It is very serious. If they look at the registry, they could end up, back in jail or prison and being fined. So you can look at it on their behalf. They cannot look at it. Also helping clients request their tiering information. People might not know what tier they fall into. So helping them request that information, confirming the accuracy of that, and then helping clients connect to folks who can help them petition to terminate their registration if they're at the point where that's a possibility for them. And my understanding is that the public defender's office may also help with retiering and getting off the registry as well. Please correct me if I'm wrong, but I believe that that's the case. So I just want to take a moment to look at some of the things in the chat just in case. So it looks like, okay, so someone from Root and Rebound is here. Root and Rebound provides record clearance and assistance with registry removal. Fantastic. And looks like Root and Rebound does intake every Friday. Ava put her phone number in the chat, 510-279-4662, not to blow you up too much, but for those people who can't look at the chat. And looks like Bay Area Legal Aid does reentry, do housing at Bay Area Legal Aid for reentry clients with 290 issues. Okay, great. So I don't know if anyone, if any of you folks or anyone else has questions or wants to say anything about your program or the services that you offer. I definitely welcome you to come off mute and say anything else. Feel free to tell us a little bit more if you want to. And does anyone have any questions?
I'll just add, hi, I'm Eva Dallaire with Root and Rebound. The law recently changed and now some record cleaning is becoming automatic, and that's happening through the state DOJ. So, and they're not necessarily talking very effectively with the courts. And so private background check companies have to get their information from the county court. And so they may be getting information about convictions that have been automatically expunged. And so, and the clients don't get notified when their cases get expunged. And so if you have any questions about that, definitely reaching out to Root and Rebound. I know Bay Legal is also an amazing organization. I don't feel any competition with them. We can help you and your clients get copies of their rap sheet and actually correct the background check if they're in a situation where their case has been expunged automatically.
Thank you so much. I just wanted to return to a question that I saw in the chat about tier 3 people in tier 3, those are the lifetime registrants not being able to be housed in PSH HUD funded programs. So I went through that very quickly, and essentially CoC funded programs can serve anyone, PSA, regardless of if they're PSH or whatever, they can serve people on the sex offense registry. They have the they can, HUD will allow it. HUD will allow them to, and again, we're just talking about CoC funding right now. HUD says that it's okay for you to deny housing to someone on the registry if there is a child living in the building and it's a site-based, project-based program. I don't think HUD wants people to do that. HUD has sent out many memos recently about criminal history information and it not being a basis to deny access to housing. It's not housing first to do so. However, it's permissible. But again, HUD says CoC funded programs are supposed to be very low barrier and you can serve people on the sex offense registry. The issue with the tier 3 lifetime ban is that there is a rule that HUD says that in certain programs, including Section 8 and public housing, if you are required to register for life, you are not allowed to be part of those programs. If you're not required to register for life, if you're in Tier 2, for example, then the Public Housing Authority can serve you. Now, again, HUD gives public housing authorities a lot of discretion to be more restrictive than what HUD says. That may be something that's changing, something may be in the air around that. But, that's essentially, the situation is that as far as HUD's rules go, it's just the lifetime ban for people on the registry. Does that make sense? Okay. Sorry, you had, Mary, you had a hand up.
Hi, everyone, and thank you, Bailey Bale, for your, I probably butchered that as well. I'm sorry.
Philo, that's okay.
Thank you for explaining that. For those of you that don't know me, I'm Mary Juarez Fitzgerald, the coordinated entry manager here in our CoC. So I just wanted to emphasize what was just said, that we do indeed have multiple PSH projects. Off the top of my head, they are scattered site that are serving folks on the, or are able to serve folks on the lifetime registry. So please, if, especially in terms of PSH, which is kind of some of the referrals that I oversee, please don't, screen folks out or assume that they're not eligible based on this background. If you have any questions about it, when PSH comes up for any of your participants, you can always reach out and we can discuss it. But we do indeed have those opportunities for folks. So I think that's one of the great things about our community. So, just putting it out there and emphasizing that this is indeed true for us and for all of you here in Contra Costa. And as Shelby mentioned in the chat, we did recently do a training with Homebase regarding this. And I'll be sure to send that out to folks later on. Thank you.
Does anyone have any follow-up questions or any questions, related to anything else we've talked about? I know this can be very confusing and sort of, I don't want to say like, it might not sound real because you've been existing for so long with this knowledge that no one can serve people on the sex offense registry. It's not true. And there's just so much misinformation out there. So, if you have questions, if you want to see rules and regulations or legal citations, happy to provide those. If you have any particular questions, feel free to reach out to us. And I guess feel free to, add any questions to the chat. So we'll just wait a second before we close out. And then in the meantime, I think Michelle, so there are a couple of different ways that you can stay in touch with the criminal legal system initiative. And one of those is by joining our newsletter, which comes out every quarter. And we send new resources out every quarter, information from HUD. It's just kind of, helpful little tidbits and things about working with people involved with the criminal legal system. I think Michelle's going to put the link to how to sign up for our newsletter in the chat. Yeah, she already did. Okay, great. And then the other thing is that we also have our website, which is has a lot of different resources that we've created on there. So we encourage you to take a look at the website. There are also some recordings to different events that we've had. So if you want to, continue to check things out and dig a little deeper, feel free to join the newsletter, take a look at the website. And then also here is our email address. It's clsi@homebasecc.org. Feel free to reach out to us at any time if you have follow-up questions or any new questions. And I guess with that, I'll turn it back over to Jamie.
Hi,
Thank
Michelle. I
you so
want
much
to
for coming.
thank you both for really, really informative training. This has the potential to really impact how folks are serving people in our community. So I really appreciate it. I wanted to remind folks, we are going to send out a link to this recording, a link to the slide deck, and we're going to have our quick, we always do a little survey to see if this is meeting your needs. Do you have other questions? But I definitely encourage you to reach out if you have specific questions. And Mary Fitzgerald, who is our coordinated entry manager, if you're not sure about something, always feel free to go to her and either she will know or we can get you the accurate information, particularly if you have questions about your program and who you could serve and that sort of thing. We would always rather have you have the right information and be able to serve folks. So I'm happy to hold a little space here if people have more questions. Otherwise, you're released. We get a little bit of time back, but wanted to appreciate everyone for showing up. This was really, really great turnout. Thank you.